28. The post-closing call, when a problem shows up after the sale. Sarah is still sitting across from Michael when she answers Daniel's call. Hey Daniel, what's going on? Daniel sounds uncomfortable. David noticed moisture around that upstairs window again after the storm last night. He pulled back some trim and says there's more damage than he expected. He's asking whether Mike and Jennifer knew there was a bigger problem before they sold the house. Sarah immediately responds. They didn't know anything about. Michael raises his hand. Sarah stops mid-sentence. That's lesson number 1. Don't start defending the transaction before you know what you're defending. Sarah tells Daniel, let me review the file with my broker, and we'll get back to you. After she hangs up, Michael asks, what do you remember about that window? Sarah starts thinking. Jennifer reported moisture after a monsoon while the property was under contract. David's inspector later noted moisture in the same general area. The Reynolds agreed to address the issue. Work was performed. Documentation was obtained. David completed his final walkthrough and the transaction closed. Michael turns the computer back toward Sarah. Good. Now let's see what the file says. This is exactly why Section 21 mattered. When a post-closing complaint arrives, your memory isn't enough. Sarah pulls up Jennifer's original text about the monsoon. Then the inspection information. Then the BIN's RS. Then the seller's response. Then the repair documentation. Michael asks, was the condition disclosed? Sarah reviews the documents rather than guessing. That's the right approach. A post-closing complaint doesn't automatically mean Sarah did something wrong. It also doesn't automatically mean David is wrong. The facts matter. Let's imagine Sarah had immediately told Daniel the sellers absolutely knew nothing about it. How does Sarah know that? She knows what Mike and Jennifer told her. She knows what is documented in her file. But unless she has a factual basis for making a broader statement, she shouldn't create new representations while trying to defend an old transaction. Now imagine she says, David had an inspection, so this is his problem. That's another dangerous shortcut. A buyer's inspection is extremely important, but it does not automatically erase seller or licensee disclosure responsibilities. Arizona has long recognized the importance of disclosure in residential transactions. One significant Arizona case is Hill v. Jones. The case involved allegations concerning termite history and whether information known to the sellers should have been disclosed to the buyers. The Arizona Court of Appeals recognized that a seller may have a duty to disclose known facts materially affecting the value of property, when those facts are not readily observable and are not known to the buyer. For an Arizona real estate licensee, the practical lesson is straightforward. Do not assume silence is safe simply because the buyer can conduct an inspection. AAC R428-1101 separately addresses a licensee's obligations concerning known adverse material facts and material defects. Let's return to the Reynolds transaction. Suppose Sarah's files show that Mike had texted her before listing. That upstairs window leaks every monsoon, but we painted over the damage. Don't mention it unless someone asks. Now we have a very different situation. That communication would raise serious disclosure concerns. But suppose the file instead shows that the Reynolds first noticed moisture during the transaction, promptly told Sarah, the condition was communicated, the buyer's inspector observed it, repairs were negotiated, work was performed, and documentation was provided. Those facts tell a very different story. That's why you don't respond to a complaint based on panic. You respond based on documentation and facts. David's discovery may also involve questions Sarah cannot answer. Was the original repair defective? Is this a new leak? Is there hidden damage? What caused the moisture? Was the condition present before closing? Sarah is not qualified to determine those technical questions. A contractor, roofer, engineer, inspector, or another appropriate expert may need to evaluate the property. Likewise, Sarah should not tell David, you don't have a legal claim. She's not David's attorney. She also shouldn't tell Mike, don't worry, there's no liability. She's not making that legal determination either. Here's where many agents get into trouble. They believe being helpful means answering every question. Sometimes the most professional answer is, that's something we need the appropriate professional to evaluate. Michael also reminds Sarah not to alter the transaction file. Imagine Sarah suddenly realizes one of her notes could have been clearer. Can she open the document, rewrite it, and save the new version as though that's what existed 6 months ago? Absolutely not. Do not delete texts, do not change dates, do not rewrite old notes. Do not create a document and pretend it existed during the transaction. Preserve the record. If clarification is needed, follow brokerage procedures and accurately identify any new documentation for what it actually is. Michael tells Sarah that he will manage the brokerage response and determine whether additional steps are necessary, including consultation with counsel or notification to the brokerage's errors and omissions insurance carrier. That is another important lesson. When a complaint has the potential to become a claim, don't hide it from your broker because you're afraid you'll get in trouble. Hiding the problem usually makes risk management harder. Sarah asks, should I call Mike? Michael says, we'll decide how we're communicating after we've finished reviewing everything. Good answer. Sarah shouldn't immediately call Mike and say, David is accusing you of fraud. Daniel didn't say that. David asked whether the Reynolds knew about a larger condition. Don't turn a question into an accusation. Don't make the conflict bigger through careless communication. ... Michael and Sarah finish reviewing the file. The documentation shows the timeline of the moisture discovery, the buyer's inspection, the seller response, and the repair process. Michael says, this is why we document. Sarah nods. Then he adds, and this is why disclosure isn't just a form. That's really the lesson of this entire course. Disclosure begins before the listing agreement is signed. It continues when the seller completes property disclosures. It affects advertising. It matters during showings. It matters when an offer arrives. It matters during inspections. It matters when repairs reveal new information. It matters during escrow. And sometimes, as Sarah just discovered, it matters after the property has already closed. The transaction may have ended. The professional responsibility surrounding how it was handled can still be examined months or even years later. That's why an effective Arizona listing agent doesn't simply ask, did the house sell? The better questions are, did I protect my client? Did I disclose what needed to be disclosed? Did I communicate accurately? And can my file show what happened? We have one section left. In section 24, from listing appointment to sold, the Arizona listing agent's final checklist. We'll bring the entire Reynolds transaction together and close the course with the habits that help agents list and sell Arizona homes effectively while protecting the seller, the buyer, the transaction, and their real estate license. Online discussion 1. Daniel tells Sarah that David discovered moisture after closing and wants to know whether the Reynolds knew about the condition. What should Sarah do before responding substantively? Answer. Sarah should involve her designated broker, review the complete transaction file, identify what was known and disclosed, and avoid making unsupported statements or admissions. The goal is to establish the facts before determining an appropriate response. 2. Why doesn't David's previous home inspection automatically eliminate every possible disclosure concern? Answer. A buyer's inspection is an important part of due diligence, but it does not automatically eliminate seller or licensee disclosure responsibilities concerning known material information. The facts surrounding what was known, what was disclosed, what the buyer discovered, and what occurred during the transaction must be evaluated. 3. Why should Sarah preserve the transaction file exactly when a post-closing complaint arises? Answer. The original records may become important in determining what occurred during the transaction and how information was handled. Sarah should not delete, alter, backdate, or manufacture documentation. Preserving an accurate record protects the integrity of the brokerage's response and allows the broker and appropriate professionals to evaluate the facts.